Good afternoon and welcome into Legal Access. We get together on Thursdays at this time to give you access to different aspects of the law. Today we're going to be talking about real estate law. If you're thinking of buying or selling commercial or residential property, today is your day. Make sure and give us a call. The phone number is on your screen, 843-848-8080, and we'll get you on the air and get your questions about real estate law answered today right here on Legal Access, brought to you by the Maguire Law Firm. On our panel to answer your questions for you, to my left is Ken Corbett. How are you doing today, Ken?
Afternoon, doing great, thanks.
Also to your left, Juliet Casper.
Hello.
And down at the end of the table, for no specific reason, Trenton Redmond. How are you guys doing today?
Happy to be here.
I'm good.
Good. All right, Ken, we'll start with you. Besides real estate, what's your firm and what else do you work on, if anything?
With real estate, usually estate planning comes into play. We do some limited estate planning, no complex trusts or anything like that, but real estate and probate related matters.
All right. And Juliet, your firm, and what else do you work on?
So my firm is Rory and Casper, and we do residential, commercial, South Carolina and North Carolina, and also some estate planning and probate work.
And Trenton, how about you?
I'm with Newbie, Sartip, and Maisel in Myrtle Beach, and we do residential and commercial real estate, as well as personal injury, collections, and business transaction and formations.
So we're well equipped to cover any questions you have today about real estate law and maybe anything else that might be on your mind as well. So again, give us a call. You've got 30 minutes, but don't wait to the very end of the show. 848-8080 is the phone number. Let's go ahead and start off with the first question. Even though you guys are not realtors, I'm sure you guys get questions about the real estate market. And I know I've been reading articles about some of the hotter markets in the United States, like Florida and Texas, how they've cooled off considerably because of some of the uncertainty that might be around in the United States right now. How about the Myrtle Beach area? It had been very hot as well. How are we doing right now?
It's still active. It's certainly not like it was a year and a half, 2.5 years ago, but we're still a beautiful place to come and people still want to come. And I think when it all fits back together with rates and maybe the complex world affairs settle down and the stock market gets balanced again, we'll start. We're already picking back up, but it's certainly not as slow as it was in the third and fourth quarter. So it's a good sign.
Yeah, lots of new construction and actually moving out in the county, seeing more developments out on Highway 90 and Loris and Aner. So those areas are becoming more popular with people moving here from the north.
Trenton, is there a difference between commercial and residential as far as the speed and how things are selling? And
There tends to be a longer timeline with commercial real estate, and from my perspective, I like doing both residential and commercial because while in residential things you have a very set process, in commercial there tends to be more variables and things to keep my brain active.
if you have any questions about real estate law, this is a call-in show, 843-848-8080. Let's go to Surfside Beach to start things off. Mark is on with us. Hi, Mark. Thanks for calling in today. What's your question for the panel?
Yeah, I'd like to know if you have a beach property in a rental district, if you can set up a fractional ownership with an HOA or maintenance fees.
Good question. I think the things you'd want to do, your due diligence are in your zoning, whatever the community you're in, county, city, town. And then obviously the next really critical element is the organizational documents, if there are any that support your subdivision or your condominium situation. So those would be initially the two documents that you would focus in on, and then get expert advice. Obviously, before you do anything like that, you'd want to do all your due diligence.
Yeah, check out if the insurance is going to change or the taxes. All sorts of things could go into fractional ownership. Certainly we have a lot of fractional ownership on the beach, with Wyndham being a big part of our beach.
Yeah, good question, Mark. Not something I would have had on my list of questions here. But speaking of, maybe working things around what the HOAs are doing, if you buy a property here along the Grand Strand and you have in mind that you want to make it into an Airbnb or a Vrbo or something like that, and the HOA has problems with that, do you have any workarounds that you might be able to convince them to let you do what you want to do?
Well, the first thing to be aware of is that in South Carolina, condominium regimes are known as horizontal property regimes. And in the Horizontal Property Act, there is a specific requirement that any restriction on short-term rentals be included in the master deed itself. So you want to make sure that the HOA is not attempting to enact a short-term rental restriction if it's not in the master deed, because they are not able to do that.
When you guys are going into closings, speaking of HOAs, do you have to, is it your responsibility or the realtor's responsibility to reveal to the buyer what the HOA requirements are for the property they're getting into?
That's a great question. It falls on us as the closing counsel to obtain what are called certificates not certificates of compliance,
Assessment.
but certificate of assessment, COA, and that's a written document that outlines whether there's special assessments, what the assessments are, whether or not there's pending litigation. It's critical that we review that. And one of the tricky things about it is some properties, and there are not many of them, have what's called a right of first refusal. So the developer may, 10 or 15 years ago, may have put a restriction in there that says before you can sell it, you have to give me the right to buy it. And that's a tricky one that we always have to make sure we're on top of that.
And some subdivisions may have two HOAs.
Yes.
May have a master HOA that you got to pay dues to, and then for your particular neighborhood, you might have dues as well. So it can be really tricky to make sure we get everybody paid at the closing table.
Our phone number's on your screen. Give us a call if you have any questions about real estate law. If you've got any general questions or something specific about you and your situation, 843-848-8080 is our phone number. And I heard you guys talking ahead of time before the show started about some of the commercials you see out there as far as title lock and things like that. Is deed theft, is that a common thing, or are people out there stealing houses?
Well, one of the most frequent things I hear is about the closing process in South Carolina is that, well, you know, this isn't the way that we did it back in whatever state people are moving
Yeah.
from. And South Carolina tends to be, in some ways, a little bit old-fashioned in its closing procedures, which means that there are protections against things like that. And so I believe we were just talking about how the Register of Deeds office is going to begin sending out letters anytime a property is transferred to notify property owners that a deed against their property has been recorded, which I think is a great practice, is going to really protect homeowners to the extent that they would need to be protected, and may take the place of some program like those types of things that you're mentioning.
I believe the county ROD, Register of Deeds office, I believe you have to communicate with them or go online to sign up so that if something does affect your property, then they notify you. But South Carolina is one of the few states left in the country where real estate transactions are under the control and have to be under the direct supervision of licensed South Carolina attorneys. So that is a different element of protection. One thing that I fear, and maybe my colleagues fear as well, is this move toward electronic signing on all documentation. That, to me, is going to be maybe the reason I retire, if I ever do, because there just seems to be so much opportunity for fraud there, and cleaning those proper problems up are not easy.
Speaking of the county and stuff, reassessments, those were already done like earlier this year, so nobody should be getting anything frightening from the Registrar of Deeds anytime soon.
No,
That was completed last year, I think,
Exactly.
reassessments,
Yeah.
Tell you what, before we run to a break, let's go ahead and run back to the phone. We have Ken and Florence on with us right now. Ken, hi, thanks for calling in today. What's your question for the panel?
I want to know if I've been here 28 years on my property. A person over here just moved in, and she has bought 2 units. They just people, I don't know what they are. Anyway, she put up a fence, and I told her, I said, you can't hook your fence to my fence. Well, now she's got a big old wooden piece of wood or pole leaning up against my fence and her fence. So I don't even really believe that the man that surveyed the thing know what he was doing, because she says, you on my property. I said, ma'am, I ain't on your property. We went back and forth, back and forth, back and forth. Well, the surveyor, he must have put a stop down, because there's never been a stop there. And like I say, I've been here 27 years. And she just been over here for maybe about 6 months.
Right.
And she bought these here rental units. You know, we got them out. You know where Cedarwood subdivision is?
No, sir, I'm not. We're not familiar with Florence, but I understand your question, and a lot of what you're commenting about really will zero in on that survey that professional completed. That is going to be a fairly accurate representation of what you own and what she owns. And when he went in and couldn't find a point, he then set something like an iron pin in the ground. But they're not perfect. They make mistakes, and on occasion they have to be corrected and analyzed. So if you feel like she's taken advantage of you in any way, I would advise you to get a copy of her map and go see a lawyer and see if they can straighten it out, because I'm sure you've been there that long. You want to be a good neighbor, and the best way to be a good neighbor is to try to resolve your differences out of court and without a lot of infighting among lawyers.
But basically, that's the next thing he has to do is try to, I mean, he's going to have to get a lawyer to be able to get a copy of the survey, though, won't he?
Well, I would think the neighbor should be able to get him a copy of it, and they try to work it out. And because if he has been using part of her land for access to his property for a particular period of time, he may have established some rights that she can't defeat.
Right.
So there's a lot of questions here that have arisen out of it. But do your best to be a good neighbor and see if you can talk her into getting y'all to have a permissive use agreement that outlines what y'all's rights are.
All right, Ken, thanks for calling in. Appreciate that. We'll talk about that during the break to see if there's anything else we can add to it, but we do have to run to a break right now. When we get back, we'd love to talk to you. If you have any questions about real estate law, that's why we're here today. 848-8080 is our phone number here on Legal Access. Welcome back to Legal Access, brought to you by the Maguire Law Firm. We're talking about real estate law here today, and on our panel to answer your questions, we've got Trent Redmond down on the end, Juliet Casper, Ken Corbett, and so we're well equipped to answer all of your questions about real estate law. And speaking of surveys, as we talked about before we went to break, whose responsibility is it? Is it the home seller or the home buyer to have the survey done ahead of time before you move in?
The home buyer should get the survey done, because that's the only way they're going to know exactly what they're buying, and if it's different than what they thought it was, they have a way to walk away from the transaction or to negotiate, some concession in the contract. But after they close and they find out there's a problem, it's a little too late.
Generally speaking, though, is it normal that you would need to have a survey done, or are you just going to believe that, okay, this is my property line?
Well, we always recommend,
Yes.
out of
Always.
an abundance of caution, that our purchasers obtain a current, accurate survey, because otherwise there's no way to know if you have a recent survey from the seller that locates the property lines and any improvements on the property. Then, of course, that reduces the chance that there's
Right.
an issue. But we do recommend that buyers obtain a survey.
A buyer sent me a survey last night and asked me if he should get a new one, and it was a couple of years old. I said, well, here's the dilemma. It's like you go to your doctor and say, I want a physical, but don't do blood work. He can't give you a full picture of what your health is. It's the same thing with us as lawyers. If they say we don't want a survey, then we can't give you a total picture of what your situation is like. And for title insurance, lenders automatically get coverage over survey matters.
Right.
But an owner doesn't unless he has a new survey. So that's why we recommend it. And we get a waiver signed, because 3 or 4 years later, they'll have a fence fight with their neighbor and say, well, why didn't we get a survey? And we said, well, we offered it and you waived it. So that's, it's critical. In certain risks, it's risk associated with it. If you've got a new construction, the risk is very limited. If you're out in the country and there's no fences around, you may have some road right-of-way issues,
Right.
but could be a fence of the neighbors 5 feet over onto your land. So
True.
depending on how long things have been there.
All right, let's go back to the phones. Remember, our phone lines are open if you have any questions about real estate law. We've got Tina in Myrtle Beach on with us right now. Hi, Tina. Thanks for hanging on. What's your question for our panel today?
Hi, my question's about residency, because I had a second home here in Myrtle Beach, and now I was paying the higher tax on that because I was not a resident. Now I'm purchasing a another house that I'm going to be a resident of. I'm going to change my residency. So it's my understanding that immediately I'll be paying a lower tax on that house, correct?
Well, not immediately. Actually, when deeds get recorded at the courthouse, the tax office will put the rate at the higher rate until you as the buyer come in and fill out the forms to say that you're a primary resident. They're going to want to see your driver's license been changed over. They may want to look at your tax returns, but it does not happen immediate. You have to fill out the paperwork.
At your closing, we provide a service and we give the paperwork to the buyer that says you go online with the horrycounty.org and you go to the real estate division and you go to the assessors, and there's a form there that allows you to do it. And hats off to the county, with 70 or 80,000 new people moving here over the last few years, they've made they've streamlined it to make it a lot easier. But you have, as the buyer, you have to file for that primary residence and prove to the county that you are a resident in order to get that substantial tax break.
But it is immediate in the sense that you can obtain it for the current tax year. In other words, you don't have to reside at the property for any period of time before getting that primary residence tax benefit. I know for the benefit that comes with the exclusion of gain from capital gains taxation, you generally have to reside in the property for 2 years for you to obtain that benefit. And there's no such time limit when it comes to the primary residence tax rate, as long as you apply and meet the county's requirements for that.
As far as saving money is concerned, also, don't they have the homestead exemption that older residents or residents that have been here for a while can
Sure.
claim?
After you've been here a year and if you're fully disabled, you can get it. But after you're 65, I believe, you can apply for the first $50,000 not to be taxed. And interestingly, if she bought a property that the primary residence was established on January 1 and she bought it in November of the same year, that rate would apply for the whole year. But it changes as of January 1 of each year. So that's why it's important that you get that application in for your primary residence as soon as possible.
And to find out more about that, they just call the county tax office?
Or just go online with horrycounty.org, and there's a tab there that explains everything, makes it user-friendly.
All right, Tina, good question. Hopefully you can save some money on your tax bill this year. If you have any questions like Tina or anybody else, give us a call. The phone lines are open at 848-8080. Going to run to a quick break right now. As soon as we get back, we'll have our final segment. So if you have any questions, make sure and get your calls in right now. Welcome back to Legal Access, brought to you by the Maguire Law Firm here on WMBF News. We're talking about real estate law here today. If you have any questions, we've got a great panel here to answer all your questions. We've got Ken Corbett, Juliet Casper, and also Trenton Redmond here to answer your questions. Again, 848-8080 is the phone number here. And as you mentioned at the beginning of the show, that a lot of you also deal with wills, trust, and estates. And one of the questions we usually get whenever we do that show is like, hey, I've got a house and I want to leave it to my kids. I'm just going to put their name on the deed right now so that they don't have to worry about any kind of probate when it comes down to the time of me not being here anymore. Is that a good idea or not? Why not?
No. Not a good idea for a couple reasons. When you bought the property, you paid a certain amount, and if you add your child onto that deed, the basis in the property is that amount that you paid for it. If the child inherits the property, it's the market value at the time of death. So potentially you could be giving your child a tax issue. If they don't live on the property, they can't make that exemption for capital gains, and they'll be looking at taxes.
Right.
But more importantly, you give up a lot of your own power, because now if you wanted to sell it or mortgage it, you got to get your child to sign off. And that can be difficult. Some families have family squabbles, and you're inviting trouble.
And if your child gets into any problems, or if they get married and they get divorced, then that house is part of their property as well, that the divorced spouse can now claim part of at least.
A great alternative if you want to retain the tax benefits of having the property as your primary residence, and if you're willing to give up a degree of control over the property, but you do want to avoid the probate process, is to convey the property to your children and reserve what's called a life estate for yourself, which is you retain the exclusive ability to use and occupy the property for the duration of your life.
A lot of people come from other states, hear horror stories in their states about taxation and
Right.
probate. Arguably, probate in South Carolina is not a complex process. Usually it's pretty straightforward. There's no extra tax. There's some administrative fees, but South Carolina follows the same as the federal guidelines. So I think it's what, $13-14 million that
Right.
unless you have more than that, you don't have to pay any probate taxes.
Right.
So it's not as difficult as it seems, but there are ways to seek professional advice to, as I say, do the life estate and avoid probate
Right.
and still have some control over the property.
And one time I've gone through the probate office here, at least in Horry County, it was a very simple process, so nothing to be afraid of. Now, as far as, we mentioned the word easements earlier, what if you've got a big property and like a big rural property and somebody's driveway goes through your property and you've been letting the old owner use that driveway for years and years and years, but now you want to sell your property, and do you have to have that easement in there so that the new owner will let the other person drive through your property to get to their property?
Easement law is very complex and can be, and most of the time easements should be established in writing and in the chain of title. One recent case we had was the property owner sold an 4-acre tract inside, and they had a platted easement agreement, but then they made an outside agreement that says, well, let's move this road over here. Well, when the owner got ready to sell his 4-acre tract, we had to go in and revise the easement agreement because they need to be specific. Right. You need to know if you're going to be burdening someone's property by an easement, it needs to be in writing and specific. Otherwise, without an agreement, it goes to court, and then there's a big fight about how long you've used it, whether you've obtained rights to it, whether you have other ways to get to the property. So easement law is interesting.
It is, and it's preferable to see the easement on a plat. That makes it clearer than just saying, I'm given a 30-foot easement that's running along the west side of the property.
Yes, exactly.
It's much easier to have a plat.
That's right. Yeah, you might have heard of DTR, which is define the relationship. We want to DTE, which is define the easement.
That's right.
Let's go back to inheritance for just a second. I mean, if somebody leaves their house and property to a lot of their children or a lot of heirs, and let's say 40% of them want to sell and the other 60% want to hold on to the property, how is that something like that settled generally?
Thankfully, there is a statutory right to have what's called a
Partition
action. Thank you. Yes, drawing a blank. Where if siblings own it and one wants to use the beach house and the other one says I never go to the beach and they can't reach an agreement, then one of them can bring an action and have the court sell the property and divide the proceeds up. So there are ways to do that. It doesn't always end up being friendly, but there are mechanisms for that.
And if it's acreage, they can do some sort of survey to carve up the different parcels for people that want to keep it and people that want to sell it.
If you can come to an agreement in that situation and have a survey done and divide it up amongst yourselves, that's much more preferable to filing a partition action, which can often be contentious and has to be done through the supervision of a court.
Sounds like you guys have surveyors on speed dial. Okay, we got a minute left in the show. Real quick, if you can do this in like 30 seconds. Squatters. I mean, we hear about squatters around the country. If somebody just takes over your property, do you have a right to kick them off, or do they have a right to just stay there because they want to?
Most tenants in South Carolina under a written agreement have rights, but if they don't have a written agreement, the courts really defer to landlords instead of tenants. So we have a good system through the magistrates courts to get rid of squatters.
All right. All right, guys, thanks so much, and thanks for the calls here today, and thanks for watching Legal Access, brought to you by the Maguire Law Firm. Next week when we get together, we're going to be talking about personal injury. So if you have any questions in advance, make sure to go ahead and give it to us in advance. The email address, legalaccess@wmbfnews.com. Personal injury, that's our topic next week right here on Legal Access. want to thank our panel here today, Ken Corbett, Juliet Casper, Trenton Redmond. I'm Dave Priest. See you again next Thursday right here on WMBF News.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific legal advice.